There is a rule buried inside a federal program that has already taken the homes of hundreds of thousands of American families. It runs on a 5-year clock. It was written into law decades ago, and most homeowners over the age of 60 will never hear about it until the day their family is sitting in a nursing home office and learning the truth for the first time. The government is going to bill them. The government is going to put a claim on the estate, and the government is going to take the house they spent 40 years paying off, the house their children grew up in, the house they always thought would be the legacy they left behind. The Medicaid 5-year rule takes your home, and most seniors never know. I am going to walk you through every single part of that rule today, the exact dollar amounts at stake, the exact rules that trigger the penalty, the exact documents that beat the penalty altogether, and the exact order you need to file them in. Stay with me, because the 5th thing on this list is the one 9 out of 10 seniors never even hear about. If you only learn one document from this entire video, make it that one. It will save your family between $15,000 and $35,000, and in many states it costs less than $200 to put in place. Some versions cost nothing at all, but you cannot use it if you do not know it exists, and that is exactly the trap the system has set up. Let me start by explaining why this rule even exists, because the reason matters. Most people do not realize that Medicaid is not just a healthcare program. It is the largest long-term care insurance program in the United States of America. It pays for something almost nobody talks about openly. It pays for nursing home care. And the average cost of a nursing home in America today runs somewhere between $8,000 and $12,000 per month for a single person. For a married couple where both spouses eventually need care, that number doubles. We are talking between $16,000 and $24,000 every single month. Almost no family can pay that out of pocket for more than a few years. The numbers are simply too large. That is why Medicaid exists. The government steps in. The government pays. But here is the part the government does not put in big letters on any brochure. The government is not paying this bill out of generosity. The government is paying it as an investment, and every investment gets recovered. The government pays for your nursing home today. Then it puts a lien on your estate. It waits for you to pass away. Then it sells the house. It sells the bank accounts. It sells the investments. And it collects everything it spent. This is not a mistake. This is not an oversight. This is a designed system of cost recovery. The courts were not set up to protect families. They were set up to process estates and to recover funds. And the 5-year rule is the engine that makes all of it possible. Every year, hundreds of thousands of American families lose part of their estate because nobody told them about this rule ahead of time. The rule was sitting in the law the entire time. They just never knew to look for it. That is what we are fixing today. Now let me explain exactly how the rule works, because the words 5-year rule do not tell you anything on their own. The legal name is the Medicaid look-back period. It applies to any person who applies for Medicaid long-term care benefits after their 55th birthday. When you submit that application, the state does not just look at what you own today. They look backwards. 5 years. Every single financial transaction you made during the previous 5 years. Every gift, every transfer, every property deed, every withdrawal, every loan you made to a family member, every payment above a certain amount. They are looking for one thing and one thing only. They are looking to see if you gave anything away in order to qualify for Medicaid, because if you did, the law says you have to be punished, not fined. Punished with time, months of nursing home bills that Medicaid will not pay, months that you have to pay yourself, months that your family has to pay, or months that force the sale of the house to keep up. Let me say that again because this is the line most people miss. The penalty is not a dollar amount. The penalty is time. Time during which you are not eligible for Medicaid. Time during which the bills keep coming. Time during which the savings drain out of the estate. And the exact amount of that time depends on the second rule on this list. That is the rule the state uses to turn your gift into a specific number of months. That is the rule that decides exactly how many months of nursing home bills become your family's problem. Pay attention here, because this is where the math becomes real. Rule number 2 is called the penalty divisor. Every state has its own number. That number is published by the state Medicaid agency, and it changes once a year. In most states, the divisor sits somewhere between $2,000 and $15,000. Some states set it around $6,000. Some states set it lower. The exact number changes, but the rule does not change. They take the total value of every gift or transfer you made during the 5-year look-back. They take the sum. They divide that sum by the state's penalty divisor. The result is the number of months during which you will not be eligible for Medicaid. Here's a real example so you can see how it works. Say 3 years ago you helped your daughter with the down payment on her first house. You gave her $50,000. The state finds that transfer during the look-back period. They add that transfer to anything else they find. They divide the total by the state's divisor. If your state has a divisor of $6,000, $50,000 divided by $6,000 gives them 8.3 months. That means for the next 8.3 months, Medicaid will not pay. You have to pay. Your family has to pay. At $10,000 a month in nursing home costs, that runs to roughly $83,000 out of pocket before Medicaid kicks back in. Most families do not have $83,000 sitting in a bank account waiting for this moment. So they sell the house. They cash in the investments. They drain the savings. They wipe out the legacy. And it all started with one gift that nobody thought twice about because nobody told them about the 5-year rule. That is the penalty divisor. That is rule number 2. And that is the rule most seniors have never heard of until it is too late to undo the gift. Rule number 3 is what happens after you die. This rule has its own name. It is called Medicaid estate recovery. This is the part that scares families the most, and for good reason. Even if you did everything right during your lifetime, even if you went on Medicaid legally, even if you followed every rule and disclosed every transfer, the state can still come back for the money after you are gone. Here is how it works in plain language. After you pass away, the state opens your case file again. They add up every single dollar of Medicaid benefits they paid on your behalf while you were alive. They put a claim against your estate. Your estate includes your house. Your estate includes your bank accounts. Your estate includes your investments. Anything you owned at the time of death that passes through probate is part of the estate. The state has first claim on the estate. They get paid before your children. They get paid before your grandchildren. They get paid before any charity you named in your will, and they do not send you a warning letter. They do not call your family in advance. They do not give your family a chance to dispute the claim until after they have already filed it. They simply file the claim. And if your estate does not have enough liquid cash to pay the claim, the state has the legal right to force the sale of your home. They take the house, they list it, they sell it, they keep what they are owed. Whatever is left goes to your family. In many states, this happens automatically. In some states, your family has to file paperwork to stop it. But in every state, the government has the right to recover what it spent. And most families never knew this was coming. They thought Medicaid was free. It was never free. The bill just showed up after they were gone. Now here is where most videos end. They tell you about the problem. They make you scared. Then they leave you with nothing. That is not what we do here. We are going to keep going. Because there are things you can do. There are transfers that the 5-year rule does not touch. There are documents that protect your home completely. There is a specific order to file them in. And there is one document in particular that does something almost nobody realizes is possible. It bypasses probate entirely. It protects your home from estate recovery. And it costs almost nothing to put in place. Rule number 4 is the list of exempt transfers. These are transfers that the 5-year rule does not touch. They are loopholes that Congress built into the Medicaid law itself. They were put there for specific reasons. And most seniors never learn about them because most attorneys do not explain them unless you specifically ask. The first exempt transfer is a transfer to your spouse. You can give everything you own to your husband or your wife without triggering any penalty at all. The law calls this the spousal impoverishment provision. The reason is simple. The government does not want to make a widow or widower homeless just because one spouse needed nursing home care. So transfers between husbands and wives are exempt. But here is the trap most people miss. This exemption only works while both spouses are alive. The moment one of you passes away, the surviving spouse loses that protection. The exempt transfer disappears, and Medicaid estate recovery against what is left begins to apply. The second exempt transfer is a transfer to a child with a disability. If your adult child is on Social Security disability and their disability is documented officially, you can transfer your home directly to them. The 5-year rule does not apply. The transfer is exempt no matter when you make it. The reason is also straightforward. The government does not want to leave a disabled adult child without a place to live, but the disability must be official. It must be documented through the Social Security Administration, and the home must be transferred directly into the child's name. A transfer to a trust for a disabled child can sometimes also qualify under a different exemption, but you need an attorney to draft it properly. The third exempt transfer is a transfer to a child who is still a minor. If your son or daughter is under 21, you can transfer your house to them without triggering the penalty. The same logic applies. The government does not want to leave a minor child homeless, but this exemption ends the moment your child turns 21. If you transfer the home when the child is 20, you have a protected transfer. If you transfer the home when the child is 22, you have a 5-year penalty. The age of the child matters. The exact day matters. Do not guess. Ask an attorney. The fourth exempt transfer is a transfer of your primary residence into a special kind of trust. This is the document most people have never heard of. It is called a Medicaid Asset Protection Trust. Some attorneys call it a MAPT. It is not a regular living trust. It is not a will substitute. It is an irrevocable trust specifically designed for Medicaid planning. Once you put your house into this trust, the 5-year clock begins. Every year that passes, the penalty shrinks. After 5 full years, the house is fully protected. The government cannot touch it. They cannot force the sale. They cannot put a claim against your estate for it. But here is the catch. You must give up control of the house for the trust to work. You cannot sell it without the trustee agreeing. You cannot refinance it on your own. You cannot move out and rent it back. The trust owns it. You live in it as a beneficiary. Lose the control, keep the asset. That is the trade. The fifth exempt transfer is a transfer on death deed. Some states call it a TOD deed. Some states call it a beneficiary deed. The most common name is the Lady Bird deed, because Lady Bird Johnson famously used this kind of deed to pass the family property without probate. Here is how it works. You sign a deed that names who gets your house when you die, but unlike a regular will, this deed never goes through probate, and unlike a regular transfer, you keep 100% of the control while you are alive. You can sell the house whenever you want. You can refinance it whenever you want. You can change the deed and name a different beneficiary whenever you want. For Medicaid purposes, the transfer happens at the moment of death. Not 5 years earlier, not 3 years earlier. At the moment of death, which is outside the 5-year look-back window, so the rule never triggers, but only certain states recognize this deed. Florida has it, Texas has it, California has it, Arizona has it, Nevada has it. About 28 states have some version of it. If you live in one of those states, this is the simplest protection available. If you do not live in one of those states, you need the Medicaid Asset Protection Trust instead. That is rule number 4. The 5 transfers that do not trigger the 5-year penalty. Now let me give you rule number 5. This is the one I told you almost nobody knows about. This is the document 9 out of 10 seniors never file. If you only learn one document from this entire video, learn this one. Because this is the document that does not just beat the 5-year rule. It does something else at the same time. It saves your family tens of thousands of dollars when you die. It removes the house from probate entirely. It names the person who gets the house at the moment you pass away. And in the states that recognize it, it costs less than $200 to prepare and record. The document is called a transfer on death deed. Some states call it an enhanced life estate deed. Some states call it a beneficiary deed. The most well-known name is the Lady Bird deed. It works like this. You sign a deed. You record the deed with the county recorder in the county where your house is located. You keep living in the house exactly like before. You keep owning the house exactly like before. You can sell it, refinance it, or revoke it at any time for any reason. The only thing the deed does is change what happens at the moment of death. Instead of your house going through probate, it passes directly to the person you named on the deed. They receive a death certificate. They take the death certificate to the county recorder. They file an affidavit. The title transfers into their name. That is it. No judge. No executor. No court fees. No waiting 6 months for the estate to open. No bond. No accounting. No public notice in the newspaper. Just a simple deed that handles everything in a single step. Now let me give you the actual numbers, because this is where the value becomes impossible to ignore. The average cost of probate in America today runs between 3% and 7% of the total estate. If your house is worth $300,000 and your other assets add up to another $200,000, your total estate is $500,000. 3% probate cost is $15,000. 7% probate cost is $35,000. That is what your family pays out of pocket in attorney fees, executor fees, court costs, and waiting time delays before they can touch a single dollar of anything you own. With a ladybird deed, that probate cost drops to zero. With a regular transfer on death deed, the probate cost also drops to zero. The deed itself costs between $50 and $200 to prepare and record. You save between $15,000 and $35,000. And you also avoid the 5-year Medicaid penalty entirely, because the transfer happens at the moment of death, not during your lifetime. That is what this single document does. It bypasses probate. It beats the Medicaid 5-year rule. It costs almost nothing compared to what it saves. This is rule number 5. This is the one almost nobody files. This is the one your family needs to put in place this year. Let me give you the order to file everything in, assuming you have time and you are not facing an immediate nursing home admission. First, talk to a Medicaid planning attorney. Find one through the National Academy of Elder Law Attorneys at naela.org. Ask specifically about a Medicaid asset protection trust for your home. Second, sign a ladybird deed if your state allows it. File it with the county recorder. The cost is between $50 and $200. Third, sign a durable power of attorney for finances. Cost is between $100 and $300. This one document prevents your family from going to court for a guardianship if you ever become unable to manage your own affairs. Without it, a guardianship costs between $3,000 and $10,000 in legal fees. Same protection. One costs $200. One costs $10,000. Fourth, update your will. Make sure it is current. Make sure the beneficiaries are still alive and still want to inherit. Make sure the executor is still willing and able to serve. A will that is 15 years old is often worse than no will at all. Fifth, check your state's homestead exemption. Most states have one. It reduces the taxable value of your primary residence. In some states, the exemption saves you up to $3,000 every year on property taxes. 20 years of that savings is $60,000. None of this requires court action. None of this requires your family to hire an attorney after you pass away. All of it happens while you are alive and well. Now let me give you 5 specific things to do this week. These are not someday. These are not next year. These are this week, today or tomorrow. First, go find your house deed. It is in your filing cabinet, your fireproof lockbox, your safe deposit box, or your county recorder's website. If you cannot find a paper copy, go to the county recorder portal online and search for your address. The deed will come up. Save a copy, look at it, read it. Understand what you own and how you own it. Second, write down which of the 5 documents I have just mentioned you already have. Ladybird deed, yes or no. Medicaid asset protection trust, yes or no. Durable power of attorney, yes or no. Updated will, yes or no. Homestead exemption filed, yes or no. Third, for any document you do not have, search the name of the document plus the name of your state. Search Ladybird Deed Ohio. Search Medicaid Asset Protection Trust Pennsylvania. Read the first 3 results. Read the official state description. Understand how the document works in your specific state because the rules vary. Fourth, call an elder law attorney in your county. Ask for a 1-hour consultation specifically about home protection documents. The cost will be between $200 and $400. Bring the list you wrote down. Tell them what you have and what you do not have. Ask them what to file first. Fifth, do not wait. Every one of these documents has a window. Every one of those windows closes the moment something happens to you, the moment you are in the hospital, the moment a doctor questions your capacity, the moment the court gets involved. None of these documents matter once that moment passes. The time to act is now. Let me close this out. If you watched this entire video, you now know more about the Medicaid 5-year rule than most estate planning attorneys volunteer to tell their own clients in an entire hour-long consultation. But knowing is not the same as doing. The best thing you can do right now is send this video to one family you love who has aging parents. That one share might save them the family home. Most of these documents cost less than $200 to file. Some are completely free. But if nobody tells them about them, the system takes everything they worked for. If you are not subscribed to this channel yet, do that right now and hit the bell. Estate planning rules change every single year. When they change, I break down exactly what the change means for your specific situation and your home. That is what this channel is here for. And finally, do not put any of this off until next year. Every one of these documents has a window. Every one of those windows closes the moment something happens to you. Once you are in the hospital window, once the court gets involved, once a doctor questions your capacity, none of these forms matter after that moment. The time to act is now. Go find your deed today. Check which documents you already have. Search the missing ones with the name of your state. Call an elder law attorney this week. Then file the ones you do not have. That is how you protect your family's home from the government's 5-year rule.